This is one in a series of interviews sponsored by the New Hampshire Bar Foundation Legal History Committee. Our narrator is the Honorable William J. O'Neill, who is currently an Associate Justice of the New Hampshire Superior Court. He also served on the District Court bench for 14 years and in the Office of the Attorney General for 9 years. I'm Deborah Fauver, and I'm one of Judge O'Neill's former law clerks. Our court reporter today is James Connolly, who took up his profession many years ago with the encouragement of Judge O'Neill. Our video technician is Mr. Connolly's son, also James Connolly. Judge O'Neill, can you tell us where you were born and raised?
I was born and raised in Manchester, New Hampshire.
And what schools did you attend here?
I attended the local parochial schools, including St. Joseph's High School, and then went on to St. Anselm's College, where I got my Bachelor of Arts degree.
Can we assume from that that your ethnic background is Irish Catholic?
I think you can more than assume that. It's a fact.
Okay. And how did you decide to become a lawyer?
I don't know. I just always wanted to be a lawyer. I was active in public speaking in high school. In certain oratorical contests, I just had a liking for it. And then I had a relative of mine, William McCarthy, who was a lawyer, and then Jack Sheehan. I sort of hung around over at his house for a good many years and just liked what I saw and decided to become a lawyer at a very young age. I really never had any doubt in my mind.
Do you remember how young an age that was?
Probably early high school, somewhere in that area.
And how did you decide on where to go to law school?
Same reason. Both of those gentlemen that I just mentioned were graduates of Georgetown Law School. So I decided that that's where I wanted to go, and that's the only school I applied for, and it's the only one I went to.
What if you hadn't gotten in?
Well, you know, the farmers in New Hampshire, they always say, you never roll up your pants till you come to the edge of the stream. So I don't know what I'd do. I probably would have applied in Boston or some other law school, but in those days, it wasn't like it is now in getting into law school. What you needed was transcript of your grades, which if they were any good, and a $5 bill, and that got you in. The difference was once you get in, it was hard to stay in because the attrition rate was so high, and Georgetown was one of the highest in the country.
Do you remember how big your class was?
140.
When you started or when you finished?
No, 140 when we started. It was around 70 when we finished.
No, where?
But that was a night school as well, and of course a lot of them go and think that they're going to like it, and they don't. But the attrition rate in the day school was pretty much as high as that, as I recall, anyway.
Did you always intend to come back to New Hampshire to practice?
Yes.
And where did you first work? Or where did you first look?
Oh, I first looked, after I passed the bar in 1957, I went around to a few of the law firms, and they just weren't hiring anybody. There wasn't anybody available.
Did you ever get the sense that being Irish Catholic worked one way or the other for you?
Yes, I remember going to one in particular law firm, a large law firm, and the interview went just about like this. Where did you go to school? I went to St. Joseph's High School, St. Anselm's College, and I graduated from Georgetown Law School. And that pretty much concluded the interview with a remark that, well, we're not hiring right now, but we'll keep you in mind. That's the feeling I got, and I immediately went over and talked to Jack Sheehan, and I said, hey, what's going on? And Jack said, well, you saw what was going on. I don't think that's true today at all, but I got that feeling, and after that I went back to Washington and got my master's degree, went back to my job at the Library of Congress, and got my master's degree in law at Georgetown, and then came back subsequently.
Do you have a sense as to when that prejudice might have changed against?
I think in probably the mid-'60s, but I really don't know. I really never paid much attention to it after that. I really didn't see it, but I felt it, and maybe it wasn't there, but it certainly seemed it to me.
How did you get back up to New Hampshire after you had been down working for the Library of Congress again?
Well, after I got my master's in 1958, I wanted to get back to New Hampshire for a lot of reasons. I didn't care that much for Washington, but I was down at Hampton Beach, down at my aunt's cottage down there, and my uncle, D. Frank O'Neill, who was a political writer for the Manchester Union Leader, was there, and I asked him if there were any jobs in Concord area or the State House, and he said yes. He said the Department of Public Works and Highways are looking for a lawyer. They just got rid of a lawyer that they had. So I said, who do I see? And he said, you see John Morton. He's the head of the Department of Public Works and Highways. And I said, where is he? Well, he happens to have a place up at Concord Point, I think it's called, up in Rye. So I jumped in my car and I drove to Rye, and there was a Rockingham Hotel or something, I can't think of the name of it, but anyway, I went into a hotel and I said to the fellow in there, I said, do you happen to know a John Morton around here? He says, sure, come here. Walked out on the veranda and he says, there he is, standing right over there with the deputy, Robert Whitaker. I said, thanks, but do you know him? He said, yes, I'm his brother Richard. So I walked over to introduce myself and had a conversation with the two gentlemen, and they said, we talked salary, and they said, you clear this with Mike Slattery in the Attorney General's office, and you're hired. So I called Washington, said I won't be in Monday. I called up Mike Slattery, and I told him I met him the next morning, and I was hired.
That seems too easy. Were you surprised that it was such a quick job to get a transition from Washington to New Hampshire?
Well, I'm not too sure surprised is the right word, but I certainly was gratified that I had a job. I took a job at half the salary that I was making in Washington, but I wanted to get back here. And
what did they have you doing?
I was like counsel for the commissioner, and I did the legal advice to them on designs and construction and right-of-ways and so forth for them during that year. Still being part of the Attorney General's office, because all lawyers were responsible to the Attorney General that were working for the state.
Now, you didn't stay there very long. You ended up fairly shortly thereafter at the Attorney General's office.
That's right. I was supposed to stay longer, but within a year, the Martin O. Nelson murder case broke out and I was asked to come over and assist in the preparation of that case.
Can you tell us a little bit about the facts of that case?
Yes, that was sometime in fall of '59, as I recall. I may not have these dates correct in a lot of these because I haven't done any research for this at all. I'm doing this right out of my head.
It's okay. We'll let other people look up the dates.
That was a murder of a fellow named Maurice Gagnon, who was a plastics manufacturer from Lincoln, Rhode Island, whom Martineau and Nelson had broken into his trailer and burglarized it. And they were supposed to go to court, and he was going to testify against them. I believe it was that week. So they picked him up at his plastics manufacturing place and in his own car drove him north through Massachusetts and into New Hampshire, trying to convince him not to testify. And apparently he refused, and they shot him.
The case citation says that he was found dead in his car in a parking lot in Nashua, and that it was a big white convertible.
That's correct.
And I wondered, do you remember the image of a dead person being shot in a white convertible? Sounds to me like a lot of blood. Do you remember if it was a... There was blood,
and I didn't see the body. I didn't get down to Nashua. But it was a convertible, and he was found in the parking lot, which is located across from the old Superior Courthouse.
In Nashua?
In Nashua, which is still there. But that was a rather interesting case, very interesting. It was charged them with first-degree murder on 2 counts, and the jury convicted them of both.
Both Martineau and Nelson?
Both Martineau and Nelson. Martineau was the one who allegedly shot Mr. Gagnon, and it was a capital punishment case, a capital case, and the jury returned a verdict about 11 o'clock at night or somewhere in that area. Guilty on all charges, or most charges anyway, with capital punishment. That was sort of I'd say scary, because it was, people were weeping, the mothers and fathers and the wives, and it was kind of a scary situation. But
why was it so late at night?
Well, juries stayed out in those days until midnight and sometimes after. And it's only in recent years that they go home at 4:30 or 5 o'clock in the afternoon.
So the jury just stayed out till they were done?
Right. The jury was out approximately 4 hours, so they didn't go out until probably 7 or 8 o'clock at night, somewhere in that neighborhood. But one of the unusual things, after the verdict was rendered by, I believe it was George Woodbury, who at that time worked for the Union Leader as a historian, whose brother was Peter Woodbury, the Chief Justice of the Circuit Court of Appeals in Boston. They asked the jury be polled, and the clerk of court's name was Bullock the Gasses. And Bullock began polling the jury, and I don't know what number it was, but he got to a certain number of jurors, and he keeled over right in front of us. He was no more than a few feet from us.
Keeled over dead?
Dead. The medical referee at that time, what was his name? I can't think of his name. But the medical referee was seated as a spectator right on the side, and he hopped right to it and started trying to revive him. The fire station is located a half a block away on Vine Street. They were there in seconds, but he was never revived. So they removed the body, and we recessed. And
now it's about midnight.
Well, it must have been around that time. And Judge Grimes, William Grimes, who later was our Supreme Court Justice, asked Paul Sheehan, who was the stenographer at the time, if he would poll the jury, and Paul says, "There's no way I'm going to poll this jury. You have to do it yourself." Well, by that time, Judge Grimes was about the color of a white shirt, but he finally did it. We were told that probably the reason that Bullock collapsed as he did is because he was so opposed to capital punishment. That's the reports we had. And I don't think he wanted to do it.
Did you have a difficult time arguing a case, knowing that the verdict you were hoping for was death?
Well, I didn't argue it. Louis Wyman was the Attorney General, and he argued the case, and I don't think we had any hesitation about asking for capital punishment. Asked for it very rarely. I think we asked for it twice when I was in the times that I was in the Attorney General's office. That, another fascinating, well, it wasn't so fascinating, but at that time I had never tried a case or been in a courtroom in any case. And Louis Wyman asked me to put on a couple of witnesses, which I didn't know much before he asked me to do it, and I put the two witnesses on. And both of them I had trouble with, only because one of them said something like, the question was asked, "Did you ever talk to the Assistant Attorney General before you come in here?" And the fellow said, "No, he was a sailor that came back, was a former police officer in Nashua." I had just talked with him 10 minutes before in the corridor, and he said no. Well, now we're up at the bench, and all heck is breaking loose. Put that one on, and then another witness I put on had to do with the automobile being found when it was 0 or 5 below, and someone said they saw somebody put their hand on, I think it was Chief Regan, I'm not too sure who it was, on the hood of the car, and it was hot. Well, the car was supposed to have been there since midnight the night before. I didn't know that, and then all heck breaks loose, so I went back to the counsel table and I said to Louis Wyman, I said, "Louis, I put on all the witnesses I want in this case. I'm not going to boot this thing." So that was the last witness I put on, but my mother and father were proud of me. They were sitting in the back of the courtroom.
Now that was really your first shot in
Right.
the courtroom?
Yeah.
On a huge case like that?
Yeah.
And they were in fact convicted?
They were convicted. They were sentenced to hang, and they didn't. The Supreme Court had reversed other statutes around the country because of the way the statutes read, other state statutes, which included New Hampshire, and it had something to do, I think, with cruel and unusual punishment. Whatever it was, I believe they pleaded to second-degree murder. And they are now both out. Nelson was living up in Chichester. He married, I believe, a nun. And Martineau, I believe, is still in prison for some drug-related charges, I believe, or whatever it may be. But interestingly, the last hanging in New Hampshire was in 1939, Howard Long, which is reported in 90, New Hampshire. I can't think of the page number. But the paraphernalia for all of that, I believe, is still up in the sheriff's office in Belknap County.
Because Belknap was the last place that they executed
He was tried in
someone?
Belknap. Yes, he was.
So when they were executing people, they did ride circuit with the machinery?
No. They were executed at the state's prison, as far as I know. I never saw one. I was only 10 years old in 1939.
Okay. Can you tell us a little bit about the way the Attorney General's office was set up when you were there? You were there mostly the 1960s.
Right.
Correct?
After I came over to assist in the Martineau Nelson murder case, I remained in the Attorney General's office as an attorney until, I believe, early 1961, when I was nominated by Louis Wyman and approved by the Governing Council as an Assistant Attorney General. We had at that time, and I think I'm correct, around 4 or 5 assistants, an Attorney General and a deputy, and that was the staff, plus clerical staff. And plus
staff of total of 6 attorneys?
Yes.
And the Attorney General himself was only part-time,
Well,
correct?
Yes and no,
Yeah.
but it wasn't as full-time as it is now. Let me say that. I don't think any of it, we were there, we had to work all day, but we each had about 20 departments to represent. We handled murders, other criminal cases, civil cases, eminent domain, and we had a woman in the office who drafted most of the legislation, in which she didn't draft, we did. We assisted. So there was no legislative services in those days.
Mm-hmm.
We drafted all legislation. And it was handy because when the legislators come in, we could say, look, there's already a law on the books, here it is, and take that back to your constituents and show them that there it is. So it's probably eliminated a lot of unnecessary legislation.
Do you remember writing any particular legislation that you were fond of?
Not in particular. We wrote so much. We wrote
Yeah.
quite a bit. Not an awful lot. She did most of it. Can't think of her last name, Marion. Well, anyway.
Did you specialize at all in the Attorney General's office?
No,
or
there
was
were no
it
specialties at all. We did it. Each one did everything. You could try a murder case. You could be before the governor and council and advising them. You'd be advising departments. You could be doing anything. We had no specialties until about 1967, when I was asked to set up a criminal division by then Attorney General Judge Papagiannis.
And that was the one specialized area of the Attorney General's office, was criminal?
Right, right.
What other major cases did you work on during that period?
Well, I worked on the Edward Coolidge case involving the death of Sandra Valade and Pamela Mason in 1962, 63, 64, in that area. That was a brutal sexually related murders in Manchester. Both of these young girls were around 15 or 16 years old. Edward Coolidge was even questioned in I believe the first case of Sandra Valade. His MO was to pick these girls up in a snowstorm or some such and then take them out and sexually abuse them, murder them, and throw them into a snowbank. Both of them were murdered in the same way. Their bodies were mutilated to the extent of sexually related, their private parts and their breasts and things like that. It was not a very pleasant thing to see. I know I attended my first, my only, and my last autopsy on Sandra Valade, and it was not a very pretty sight. I didn't attend the one on Pamela Mason. I was asked to, and I refused. The United States, he was convicted. We asked for capital punishment, and the jury did not come in with capital punishment. What reasons, who knows? But he was convicted, and that was later reversed by the United States Supreme Court because of certain defects in warrants not appearing before an independent magistrate. Edward Coolidge, I believe, ultimately pled guilty to second-degree murder, and I believe he was just released from a prison somewhere down south. I thought it was Virginia. I didn't take part in the trial. I took part in the indictments and the preparation, a lot of it. We all did. Mm-hmm. It wasn't just one person. Because I was trying a murder case in Coas County at the same time that was going on. That was an interesting trial. I was charged with second-degree murder, and the jury came back with a question through the bailiff, said they wanted to know if they could come in with capital punishment, because obviously we knew the answer to that. So I think those were two of the most interesting cases I worked on. They were certainly two of the most spectacular ones. I mean, every case is important.
You had a similar case not too many years ago as a Superior Court Justice up in Carroll County. I forget the man's first name, but Wisawati.
Oh,
he
yes.
picked a woman up in a snowstorm.
Very brutal, yes. Yes, that was just sustained by the Supreme Court. Yes, he picked a woman up who was working in Portsmouth at the Naval Yard, and in a snowstorm her truck went off the road, and he came along with his dog in his truck. I don't know what someone's doing out at 2 o'clock in the morning riding around a storm, but he had offered her a ride, and he did, and then all of a sudden he went sort of haywire and drove by her home and then drove back and into a sort of a wooded area and performed fellatio or whatever, and it was brutal the way it was done, and left her there in the middle of the night. So
we tend to think of those things as happening more and more now, but it sounds as though
yes, they are.
They happened then too, though. They happened in the 50s as well.
Well, certainly not as many, but I'll get into that in a second. But I wanted to mention one thing when I was in the Attorney General's office. In 1962, we had our first civil demonstration.
The Weir speech?
No, this was a civil demonstration. Now, this was the beginning of the demonstrations that we had. It was a civil defense alert, and people were ordered off the streets in Durham. And there were a number of these groups that were starting at that time to resist this type of thing, and they refused, and they were arrested for disorderly conduct. And ultimately, I tried a number of those cases in the Durham District Court of those people, and were convicted of it and sustained later on. That was the first of those.
These being the demonstrations against the Vietnam War.
Well, this was not Vietnam. This was not quite. They weren't. I don't believe they were talking about Vietnam. I don't think Vietnam was. When did Vietnam War begin? I don't know what year it began. But anyway, I don't believe it had to do with that. I don't think they were those type. They were that type of person. So whether it was or it wasn't, I don't know why they were doing it. It wasn't really. I can't recall back that far. But, they were demonstrating against the government, telling them that they couldn't be on the street. They were against these alerts, against war. So whatever war it was they were talking about, it was against war, and they didn't want to be told they have to get off the street in the event bombs are going to be dropped.
I see. And not too long after that, the Weirs Beach incidents came up, which were
right. That was the 1964 and 1965 was the age of the riots. There were riots in both years, in 1964 and 1965, at Weirs Beach in Laconia and at Hampton Beach in Hampton. At the Weirs Beach, they had the Hells Angels from all over the country, and then New Hampshire had its own diehards, so-called. They were violent riots, I mean, just terrible. The one at Hampton Beach was probably even worse in '64 than the one at, that was on Labor Day weekend. The Weirs Beach was in sometime late June or early July. And prosecutions are extremely difficult because the police officers couldn't identify the defendants because they would take them and arrest them and bring them to a paddy wagon up on the street and then put them in, and then the paddy wagon would take them to the police station. And they'd say, what are they here for? I'd say, they must be here for disorderly conduct, but the police officer's back on the beach. And he never really identifies them. So out of the 300-odd cases that we tried in Hampton in 1964, I believe we got 19 convictions. And that was about it.
That must have been frustrating.
Right, but there was one interesting facet of that. What we had to do was try to stop the riots in '65. There was one particular defendant, or accused. One of the rioters burned a sort of a supervisor's hut, the playground area. And Paul Doyen was then an undercover man, like a lot of the inspectors were for the state police. And he caught him and was trying to wrestle him to the ground when the rioter got him to the ground with a lot of others and was pounding Paul Doyen's head into the cement. Doyen finally got a hold of some sort of a medallion or a cross or something that he had around his neck, around the rioter's neck, and he grabbed that, and I believe anyway, they left them there. Well, after the riot was all over, Doyen and a chief of police by the name of Levitt went up and down the beach trying to find out who owned this particular medallion or whatever it was. And after a substantial search for over a month, they found a woman who ran a boarding house. And she said, I know who that belongs to. And in the boarding houses, they had to register who they were and where they were from. She says, I know who he is. And they went up into the house and they found the name and found that this fellow, whatever his name was in New Haven or New Britain or wherever it was in Connecticut. Well, the long and the short of it was they contacted the police down in Connecticut, and Doyen and Levitt went down, and this fellow worked in a mill or a shoe shop or something. And as he was coming out a catwalk to cross a canal of some type, this rioter spotted Doyen, and he said, I never thought you'd find me. Well, obviously he was convicted and was sent to state's prison on our recommendation. And I called the press in at the time. Jack O'Shea was one of the reporters for the Boston Herald. And I asked him if they would probably play this up as best we can and probably avoid a riot in 1965. And they did. And we didn't have a riot in '65, and I don't think we ever had one since then. So
I mean, playing up the publicity of that case and that
rioter
conviction.
Goes to prison. So I think that was the reason. That was what we wanted, and that's what we got. So that was Then in 1965, we anticipated a riot at the Weirs. So John King was governor at the time and commissioned a committee made up of Judge Amos Blandon from the Supreme Court, Bill Green, maybe some others, and myself from the Attorney General's office. So we met and they asked me to draft some legislation, so I did. I found an Illinois statute that read something like this, as I recall: any two people gathering for an unlawful purpose shall be guilty of riot.
Pretty generic.
Yes. Well, that was just days before, as I recall, days before the riot. I believe it was a day or two. It went through the legislature and signed by Governor King before the riot, and it was used, effective immediately, and was used for the riot in 1965. And there was another terrible riot at Weirs Beach. And that case went to the Supreme Court, one of the cases, I think it was State versus Miller, I'm not too sure of the name. And the Supreme Court sustained the constitutionality of the statute.
Did you have any concerns about the constitutionality when you were drafting it?
I think any lawyer would.
So you were just hoping you could get something to work for the time being.
Right, and it now has been changed to probably comply more with the Constitution than that did.
But you convicted several people,
yes,
many
yeah.
people.
Well, I can't recall how many because I didn't prosecute them up there, the county attorney did. I argued the case in the Supreme Court, as I recall, or the Attorney General's office did. We argued it in the Supreme Court, as we did argue all cases, criminal cases.
Let me go back to one thing you had just mentioned about the newspaper and about getting the newspaper to help you play something up. Did you continue to have that kind of cooperation with the newspapers over the years, or is that something?
Oh, in the
that's
Attorney
gone?
General's office, we always had the cooperation of the media. Very good relationship. All the years that I was there, I would trust it still the same way. But I mean, we gave them information. You know, we issued press releases on a regular basis, on a daily basis a lot of times. But at least whenever we had a story, we gave it to them. And they were very good about not printing stuff that during an investigation that we didn't want printed at this time. We'll give it to you when, you know, when the time is ripe and appropriate.
As a judge, have you been able to maintain any kind of relationship like that with the press?
By and large, I have, I think. Most of the ones that I've dealt with, I have a lot of confidence in, yes.
The Superior Court judges now ride circuit, and you must not see the same reporters over and over again.
No, but you get to know the reporters, who they are, and who, you know, how reliable they are, and ones that you can confide in. It's a normal thing, I think, in everyday life. And you know those that you don't, and you don't confide in them because you can't.
Now, you were mentioning that you argued a lot of the cases before the New Hampshire Supreme Court at the AG's office.
I argued, I don't know how many, but it may be as high as 100, I don't know. I know at one time I argued 5 cases in a row, one right after the other.
In one day?
Yeah. Well, it was, if I got through in the day, but if I didn't, I get it at the start of the next morning.
Right.
And that's an interesting thing. I think one time I argued a case that I didn't have much of a chance of winning. And Judge Kennison wrote, and I can't remember the case, but it was, and I'm not even sure that this is a direct quote, but it was, the gist of it was, in referring to my argument, as he said something like the Assistant Attorney General's argument, said, counsel for the state's argument is persuasive but equally unconvincing. And I thought that was kind of nice of Judge Kennison. That's the gist of what he said. The number of cases in the Supreme Court back in those days was a fraction of what it is now. In the 60s, I'm talking about. Formal opinions were written about just about every case, even if the case had been, a question of law had been decided. There's one particular set of cases that had been decided 3, 4, or 5 times, and I used to ask Judge Kennison, why do you keep writing an opinion about this state versus hazard and state versus this and that? And he said, well, the legislature says we must render an opinion, so we render an opinion. So a formal opinion was written on about every case. I'm not too sure that's I know it's not true now, and I don't think they can possibly do it with the volume that they have. Another little thing that Judge Kennison mentioned. Judge Kennison, incidentally, I had a great respect for. He's probably my favorite judge, and probably helped me as much as anybody. We were located, I was spending a lot of time in the library over there doing research, and so did he, so I got to know him quite well, and I had a tremendous respect for him. But I can remember I wrote a brief for the Supreme Court, and the Attorney General argued the case, and he read the brief that I had written.
Judge Kennison? Or
No. The Attorney General read the brief to the Supreme Court.
Oh, that was his argument, was reading your brief.
Reading the brief, and I almost fell over in my chair. But anyway, the Supreme Court was very gracious, never said a word, but ultimately I believe Judge Kennison wrote somewhere, and I thought it might have been a bar journal, but he wrote somewhere telling people about not doing that. Don't read the brief to us. And it was an article on how to present yourself to the Supreme Court. And I remember the language was something like, and this is not a direct quote, but he said, "You can accuse us of not being able to think, but please don't accuse us of not being able to read." I've used that a number of times when lawyers come before us and read off their memorandum or their motion for summary judgment, and I'll say, "Hold it," and I tell them this story. So I've never forgotten it. And another judge that I just like to mention was Judge William Grimes, who was a trial judge from 1946 or up into I don't know when he went on the Supreme Court. But many years a trial judge while I was starting out, and I've tried to model myself somewhat after him in helping young lawyers, and he was a tremendous help. I probably tried more cases before him than any other judge, but he was absolutely super as far as helping you. Where you stumbled.
What kind of help?
Well, where you stumbled, you did something wrong. He'd say, "Are you asking leave of court to do such and such?" And he was just telling you what you should be doing. And of course, you blindly say, "I wonder what he's talking about," but you say yes. He'd say, "Well, I think that you ought to do this, and why don't you go ahead," and so forth. There's nothing wrong with that, because there's no training ground to being a lawyer. You just come out of law school and into the courtroom. But the practice of law in the 60s is when I started out, and in the 60s, is so much different than it is now. It's less hassle, less paperwork, less rules, regulations, less trials. In the 60s, the early 60s, I believe there were 5 or 6 judges. I know there weren't more than 7 judges in 1963.
On the Superior Court?
On the Superior Court. Because Judge Dunphy was the last judge of that group to be appointed. They covered all 10 counties. So obviously the courts were not open in every county all the time. So Judge Denny Sullivan used to cover Coas County and Belknap County. That was his tour of duty. And much of the work between the lawyers was done either on the phone, over a cup of coffee, or wherever, but it wasn't all writing and whatever. When a lawyer said whatever he said, his word was his bond, and that was it, and he stuck by it even if he had to eat crow. That's just, the number of lawyers at that time was, when I passed the bar in 1927, 21 out of 32 passed the bar. 32 took the bar.
In 1927?
1957.
57.
57. If I said 27, I wasn't even born.
But you felt that you were able to trust the other of the lawyers that you were coming into contact with regularly. You really felt that you could trust what they were telling you?
Absolutely. There were very, very few that you couldn't in the state. And we knew who they were. And they knew we knew who they were. And that's how you dealt with them. You did do things in writing. You did go into the courtroom on the record. But there were very, very few. They weren't a handful, one handful. Now, I can remember the midwinter bar meeting in 1957. We were on it. I think that's when it was. But just to give you an idea of the comparison between the number of lawyers today, there were probably 300 or 400 lawyers in 1957. I think we had a picture taken, one picture that you could hang on the wall.
Of the whole bar?
I believe the whole bar. I believe there are now thousands. I don't know whether it's 3,000, but there's
about
thousands.
3,500.
Oh, there you go. It's even more than I thought. Because I can remember going to the midwinter bar meeting, and I think we were honored at that time, and there may have been 50, 75 people. I think it was 6 acres out in Manchester, out of Crystal Lake somewhere. So it's a different ballgame entirely. I mean, the mounds of paperwork that go into the court, and unbelievable. I mean, it's some way it's got to stop. I mean, this can't go on. If it keeps mushrooming, we're going to run out of trees in New Hampshire, and there's a lot of judges that wish we would.
Do you have any thoughts on how to stop it?
Well, one way to stop it is to give it back to them, I suppose. I don't know how to stop it, but I know with summary judgments we're starting to give serious, I'm giving, not consideration, I'm going to do it in Belknap County, and that is when I find that there's a motion for summary judgment that appears to be unfounded, they're going to get fined for doing it.
That would be a new step. What do you think about the summary judgment procedure in general? It seems to me that every time summary judgment is granted, it's appealed to the Supreme Court, and the Supreme Court reverses the summary judgment and says, no, they've got to have their day in court.
Well, I don't think that's the reason why they grant it. Why they reverse. They reverse because they find a genuine issue of fact, a material fact. That's a question of judgment, but 95% of them are denied. That tells you something. And what happens is, and I'm not going to put the fault on big law firms, small law firms, or anybody, but they file them, and sometimes they're 2 inches thick. I mean, the files just get off the ground, and the response comes back with 2 inches thick. Well, before you know it, you got a 4-inch file in your hands, and the case isn't
You've never seen any people.
No. So, and then the judge has got to read through all of that stuff and finds an issue of fact probably in the first 5 pages. And it makes you wonder, what are we doing here? Well, some of them are filed because some lawyers figure if there's a pro seer, he doesn't know what to do, and he'll default. Now, the Supreme Court says, too bad. If he defaults, he defaults. And I don't know why some of the larger law firms representing insurance companies, I don't know why they're filing them. Not just insurance companies, but whoever they may be. Mm-hmm. And sometimes there'll be 25 tabs in there that you've got to look at. I'm beginning to wonder.
So it's not the most effective of procedures.
No, and if half of them were granted, you could understand why they're filed. If they're filed for the purpose of discovery, then I don't think that's true either. I don't know. I just don't like what I see.
Well, let's go back to the AG's office. I think in terms of the chronology of your career, we left off there. How did you end up leaving the AG's office?
Well, I had been there, I thought, long enough, and I wanted to go back to private practice, so I was Deputy Attorney General, was appointed by Governor King. And I left to go back to Manchester, but I didn't want to go into a larger law firm. With some of the experiences that I've had. So there was a part-time city prosecutor's job that was just created in Manchester, and I applied for that and I got it. And I did that for the next 3 years and engaged as a sole practitioner in private practice. Enjoyed it very much.
And how long did you do that?
3 years, until 1970.
It's a pretty quick stint. What led you away from it?
Well, there was a Manchester District Court opening, a judge's position opened in 1970, or late 69 and early 70. Judge Cretion was the judge of the Manchester District Court, and the legislature approved an associate justice to go with him full time. He retired in January or February 3rd, 1970, and I showed an interest in it, and I was appointed by Governor Walter Peterson as an associate justice, along with Judge Capistran as a justice of the court.
And that was a full-time position?
That was a full-time position.
So you shut down your private practice?
Right.
What sort of cases was the Manchester District Court handling at that point?
Well, they handled criminal cases, all criminal misdemeanors. There were no violations, so-called, in those days. Handled civil cases, small claims, landlord and tenant, domestic violence, juvenile delinquency, and neglect petitions, and abuse cases.
What would you say the majority of the work was?
I'd say criminal. A lot of traffic. I think that was the majority, but it was a pretty good cross-section. Mm-hmm. But I would say that would be the majority of the arraignments and the trials of those cases would take up. I would say the traffic, volume-wise, if you started counting cases,
right,
but time-wise, it was very
They were
Yeah,
open and shut
right.
kinds of
I
cases.
mean, you might try a DWI that takes 4 hours, and you take a speeding plea in 10 seconds. So you count both of those as a case, and it's not really the way to do it. It's in court time, and we were in court every day, all day, 5 days a week, just basically. But I'd like to just comment that as a lot of people laugh at Judge Wapner's small claims court, and I do too. But our small claims court then, and I'm sure it's the same now, was just exactly like that. Lacking the commercials, obviously, and lacking the judge getting the amount of money that he's getting for doing the same thing. The reason I say that is it was instant justice, usually decided right there. There were no lawyers to battle over pleadings and motions for summary judgment. And generally, you were sort of an arbitrator and try to figure out, and you decided right there. And I think as far as the courts are concerned, on the civil side anyway, I think it's the best there is. I don't care what anybody tells me. I think it's, people go out of there, they just want to have their day in court. You know, they go back to their local pub or wherever they go, and they'll say, well, I told that judge a thing or two. And they probably didn't. You just say, okay. They'd get mad, and they'd swear and do things like that. But you try to...
Give them enough rope?
Give them enough rope, and I never got too excited about them. I knew what they were doing. Usually it was a little thing, the wallpaper was hung upside down and then wanted their money back and things like that.
Yeah.
But it was, I thoroughly enjoyed small claims court. I will have to concede that. I enjoyed going in and listening to the people, you know, battle back and forth. Let them go. You know, just let them, and just short of a fist fight.
Did you ever have a fist fight?
Pretty close. I think we had them out in the corridor, but they didn't have any in the courtroom.
I bet you did. Were there kinds of cases at the district court level that were really difficult for you to handle?
Difficult in the sense that there's often no answer, and those were generally your juvenile delinquency cases. You had some answer. Many times your answer was YDC. We didn't like that answer. Probation.
What did YDC mean at that point?
What did it mean?
Not the initials, but sending somebody off to YDC.
Well, confinement for their minority. They didn't keep them all that time, but some of them did. But it was not a very viable alternative, but sometimes it worked. Sometimes we'd like to send them up for a weekend. It worked like that for me on one occasion. A friend of mine's daughter who did something, not that bad, and I sent her up for the weekend, and she ended up working in our office later on in years. And a very nice girl, and that taught her a lesson. So, but I think the most difficult in the sense of what you can do, which is sometimes nothing, your abuse and neglect cases. Again, you're hitting at the heart of the family structure. This
is primarily involving children.
Right, right. I mean, not only physical abuse, but sexual abuse. It's, I don't want to get gory, but I can remember one case in particular. If you ask me what cases that I had that bothered me the most, was one where the father and the mother, you know, had this daughter that was about 8 years old, and they were just unreasonably strict disciplinarians. Even, I don't know what else I can call them beyond that. But she wouldn't eat her cereal, for instance. So they would take her and put boiling hot water in the tub, and then dunk her feet into it until her feet were so burned that looking at pictures of them would make you ill, seriously. And then another occasion, she wouldn't eat her cereal, so they kept shoving it down her throat, and she finally vomited into the bowl, and they put the vomit right back in her mouth. And I remember that case well, because under this particular statute, we were supposed to include a specific plan for returning the child to the home. And I balked, and I said, I'm not returning that child to the home. I just couldn't in good conscience do it. It's ridiculous, it's ludicrous. But I got around that a little bit because the parents had to meet certain conditions that the court set up in order to get the child back. Right. And I just ruled that there were no conditions upon which these people would get this child back. And I remember going to the Superior Court, and Judge Delanus remanded it back for me to make that finding, and I remanded it back up and said, you make the finding, I've made mine. And we talked about it, and she agreed after hearing it that there was no way. That child. And we took that child out of the home and put it in another home, and the child was sexually abused in a foster home. So when you say, you know, difficult, there's oftentimes no answers. I mean, it's nowhere to send them. And the ones that lose are the children.
How did you cope with that? I mean, is that the kind of thing that kept you awake at night, or did you have some way of shutting it out?
Well, if I ever had any reason why I would want to go on to Superior Court, that would be the primary one. It got, yes, I don't say it got depressing. I'm not a depressed type person, but to listen to it every day. I mean, we had juvenile court every single day, Monday through Friday. One of us had it, the two. And after you listen, now, this particular case I'm talking about went 7 days. Mm-hmm. You get frustrated when you don't have the answer. And I mean, I had to go home at the time. I was bringing up small children myself. My wife was. I was helping her. And you see out there, you come home at night and look at your own children, and then you get a flashback of what happened today, and it isn't very encouraging. I mean, maybe it makes you a better parent, I don't know, but I didn't care for it that much. I never looked ahead to one of those cases.
No.
I used to look at the docket and see if there was one on Monday morning, if there was going to be one on for the week.
Grit your teeth.
Yeah.
The district court jurisdiction's recently gone up to, I think it's 20,000 now.
I believe it was 5,000 civil jurisdiction when we were there.
Do you think that's a good thing for the district courts?
Well, I think it's a good thing if they use it. I don't know whether they're using it. I'm not familiar with that, because we're still getting $5,000–6,000 cases. They can still get their jury trial. I believe that's been increased under the Constitution as well. But yeah, I think it's a good thing in this day and age. I mean, what's $20,000 today was probably $5,000 in 1970 of comparable amount.
Now, you were appointed to the Superior Court by Governor Sununu in 1983.
Right. And very happy to accept the appointment.
To move on.
Well, to move on is something different. I think 14 years at a district court like Manchester is, there's a burnout factor there. It's really, there's a tremendous amount of work, a tremendous amount of responsibility. I personally don't find the responsibility in the Superior Court certainly any greater than the District Court, and I think that's why they're paid the same as the Superior Court, and they ought to be, because there is a lot of responsibility and a lot of work and a lot of hard work. And I know that the full-time District Court judges in the state work hard, very hard, as do the Superior Court justices as well.
It almost sounds as though you're saying that District Court judges maybe see more people coming through the doors, more cases.
No question. They have thousands of more cases than we do, of people. I mean, just anyone that wants to go down to the Manchester District Court and just walk the corridors, and if you can get through there, you're lucky, from one end of the building to the other. And any morning at 9 o'clock, they're all over the place.
Do you miss the Judge Wapner syndrome?
No, not really. We have, as long as we can keep our sense of humor, I think you can still do the same thing at the Superior Court. You know, we still have a lot of cases that don't require juries, that don't require formalities. We do a lot of things in chambers, which is some of the enjoyment, I think, that we get out of it. I do anyway. I don't know about others.
Now, when you were appointed to the court in 1983, how many judges were there?
18.
18.
Right.
And can you compare the type of work you were doing then to the type now, 10 years later?
Well, I just think there's more volume now. I think it seems to me there's more murders and rapes than there were then. I don't understand why, but there just seem to be. I think the volume has increased even since 1983. The lawyers seem to be fighting more. There's not that much agreement on things. They come in and battle, and they won't. Motions to compel. You know, we get oodles of these things, and as I say, back in the 60s, there wasn't any such animal that I ever heard of, because whatever you had, you'd give them to them. But now we get the depositions by the carloads, the interrogatories, and we get countless things. Motion to compel answers to interrogatories. You know, how's a judge supposed to know? He got there are 5 interrogatories out of 100 that someone didn't answer. And how are we supposed to know that they should answer it? But they'll come in and battle away at it, so many times what I do is say, answer it, and hope it goes away, I guess. But,
Or deal with it at trial.
right, yeah, deal with it at trial.
Which kinds of cases do you have at the Superior Court that you find the most interesting?
Oh, a nice civil case, probably most interesting from the standpoint. I don't know.
Even with all your criminal background, you'd prefer to?
No, I don't say I prefer either, really. I probably have more background in criminal cases. I think, frankly, feel that probably criminal cases are a little easy to preside over.
Why is that?
Some of your, your products liability cases, things like that. Some of certain accident cases and multiple plaintiffs, multiple defendants, misrepresentation type cases, fraud. They can get rather complicated, and sometimes it's difficult to give a decent instruction to the jury, so that they know fully and understand what the law is in a case. It just requires a little bit more, but it's enjoyable.
Now, I remember as a law clerk helping on some jury instructions and things. Has the law clerk's job changed in the 10 years?
No.
I think the number of them seems to have increased.
Yeah, I believe we've added some, but I don't get involved in that part of it. Whoever they assign to me is fine. And work with the law clerk very closely in all cases, and they're very, very helpful to me. And you were, Debbie.
Thank you. I wasn't asking for that. What about the juries? Do you enjoy working with juries?
Oh, I love working with juries. I think I have. If I'm talking about fun, I probably have more fun working with juries, than anything else. They can be. They can be funny in a lot of times. And most of the time, I think most people don't realize how good juries are. Back in the late 50s and 60s, jurors were usually volunteers from the town selectman or the town somebody. They would volunteer, and usually they'd be men, and they'd be retired and falling asleep and couldn't hear and couldn't see or whatever. That was the type of jury you had. Now, in more recent years, our juries are made up of a cross-section of the young, the old, the middle-aged, the women and men, and all walks of life. And I think that's a good cross-section. They're far more alert and intelligent than I think a lot of lawyers give them credit for, at least in my experience. Give a couple of examples. One particular one was a drug case over in Rockingham County for selling drugs or intent to sell drugs. And it was not the strongest case, but it was fairly good case. But in any event, there was a suitcase that was taken from the defendant, and there was a document in the suitcase that the state wanted to introduce. And the defendant says, well, if you're going to introduce the statement, why don't you introduce everything that's in the suitcase? So they did. Well, the case went to the jury, and the jury found him guilty. And I talked to the jury after the case was over, just generally, and they volunteered some information for me. I said, we were trying to figure out why they put the suitcase in. But they said, what we found, we emptied it all out. And we found marijuana in the bottom of the
suitcase.
Of the suitcase. And the defendant, for some reason, within that suitcase was a list of furniture that he sold. He said he was selling furniture, and it had like a hutch, one such and such a hutch by the name and so forth. Well, as it turned out, he had a whole list of things. Well, what it was, one of the jurors was in intelligence in World War II, in service. And he was a code breaker, the Japanese code. And he broke this code down to show what was sold, who it was sold to, and how much he got for it.
It was a record of his drug sales, not really a list of furniture.
Right, it was a record of his drug sales. Now, I never would dream that, but the jury certainly did it. And one other case where...
Now, the defendant in that case never knew that a World War II code breaker had
State police and the rest of them had never looked in a suitcase, from what I can recall, because the prosecutor didn't know what was in it. But in any event, there was a burglary case in Belknap County where a fellow was a fairly strong case, and when the defendant was arrested, he was arrested with a beer can in his hand. a Budweiser beer can. And defense counsel asked the police officer, the arresting officer, he said, did you take fingerprints of that beer can? Well, there was an objection, and I said, sustained. It doesn't make any difference. This has got nothing to do with the crime. He wasn't at the scene or anything. Well, the case went to the jury, and they found the defendant not guilty. So I inquired of the jury, how come you found this defendant not guilty? Well, this outspoken person from New York originally, somewhere, said, well, we found him not guilty because they didn't take fingerprints of the beer can. Of which I immediately turned scarlet. And I said, well, wait a minute. There's nothing that says that they have to take fingerprints. I already ruled on that. Well, we don't agree with that. He said, I've heard and we agree that they should take fingerprints of everything they take from a defendant. I said, well, would you mind telling me where you heard that or where you saw that? He said, I heard it on Perry Mason.
Oops.
Well, there's a case of where the jury just made a mistake. And I just had a rape case recently where it was the victim, the daughter, testimony against the father, and it was a fairly good case. The defendant merely took the stand and says, I didn't rape my daughter, period. There was no question beyond that. Well, in this particular county, the jury's upstairs, and you can hear from chambers from time if they talk loud enough. And my law clerk heard a woman in a loud voice say, one of the jurors say, well, after all, he only did it once. Well, they found the defendant not guilty. So they were all done at that time. And I said, by the way, what were the reasons why you found him not guilty? I said, did it ever come up that he only did it once or something like that? And one juror said, yes, that's right. He only did it once. And I believe that was the basis of their finding of not guilty. And then when I told them that you had no right to assume that, any more than you had a right to assume that it was a third time. They could probably assume more that it was, but not to make that the reason for it. So they were a little disturbed when I told them it wasn't the first, it wasn't the second, it was probably the third.
Now, what happens when a jury convicts and you have reason to suspect that maybe they weren't doing it for the right reasons, or maybe you're not sure, they just convicted when you might not have personally.
Well,
now, you've got to sentence the person.
Well, that's true. Then you may take that into consideration on sentencing, I suppose, like you can anything. That would have to do with the strength of the case. But normally speaking, if a jury finds him guilty, that's as far as I'm concerned, then you take it from there, they did it, and you take the rest of the background that you take into consideration on sentencing. So, I had one other case which went on for a number of weeks, 6 weeks, I believe, a civil case. And the jury was out for about 5 or 6 hours and ready to come in. And they settled a case for $500,000. And I went in and talked to the jury and said, they've settled this case for and they said, I hope they didn't give them more than $10. And they said, yes. I told them they gave them $500,000. I thought they were going to kill me, let alone the others. So, you know, juries generally are right. They're right on target. And in that case, I would have done the same thing. But simply because we disagree or agree, it doesn't make any difference. It's up to them. They've got 12 minds, we've got one. They've got people from all walks of life, we've only got ourselves in our own profession.
Now, you do something a little differently than some of the other judges in that you often tape your jury instructions and send them in so they can hear them again. What's the reasoning behind that? Well,
we give the juries the instruction, and they get it for the first time. We've gone through law school to learn all this. We probably sat down with the lawyers for an hour or whatever, going over the instructions. And then we give it to them and expect them to remember it. Well, I don't think they remember it. They may, but I see no harm in giving them the instructions on tape, very simple little Sony that I have, and send it into them. And in the almost all cases, they play it. And in the vast majority of cases, they play it more than once. And in many complicated cases, I had an eight-week legal malpractice case over the Christmas holidays. Had they not had it, they never would have come close. They didn't, as it turned out. It was a hung jury, but they had played it like 5 or 10 times. And that's many times the case. They're getting language that they never heard. They're getting concepts that they can't understand. And if you outline these in their language, and they can play it and understand it. And many times I've had cases where they say, we were going to find the other way until we read your instructions and you told us this. So it works both ways in both civil and criminal cases. I've had defendants who were found innocent because of what I told them, and I've had those that are guilty and should have been found guilty that they were going to find innocent and find him guilty because I'll say something. So
Because
there's
they
no
heard it
harm
a
in their
second
claim.
time.
Right.
Do
So
you
I
ever let
find
them,
it.
do you ever let them take notes?
No, I have not let them take notes. There's a pros and cons on that. If there's a very complicated contract case or something that's going to go on for a long time, we have let them take notes. I just haven't had any where no one's asked me to in the first place. The reason why they don't take notes, I don't know. It may be that back when the jury system started in England, jurors were the poor people, the peasants. They were not the only ones that could read and write were the gentry or whatever they're called, the royalty. So they were the peers and they couldn't read or write, so it may have come from there, I don't know. But there's a danger of them taking notes, that they may be taking a note of something that's completely insignificant and missing something that is. Then again, you have, can they take them home? Can they take them into the room with them? Or there be notes all over the place? It probably just isn't a good practice. And other than the fact that it hasn't been done, I don't know the reason.
That's fair enough.
Yeah.
What about sentencing? Do you have any particular philosophy in sentencing?
Well, first of all, the seriousness of the crime, the person's background, you know, what is he from, what kind of a criminal record does he have, the parameters of the penalty involved, and consistency with other cases, taking into consideration that in all sentencing you punish the guilty, you deter them and others from committing the crime again, and last, and in that order, rehabilitation of the defendant. So we take those into consideration, but surprisingly, both at the district court and superior court, I think you'll find reasonable consistency in the sentences, but take as much information as you can get that has a bearing on what you should do.
Do you think things like community service and other kind of alternate forms of sentencing are particularly useful?
Yeah, I think they can be useful. I've done it on occasion. It's seldom recommended, however. But it's sometimes a viable alternative. I can remember making a fellow in Manchester clean up an area out at Massapequa Lake, and it took 3 truckloads before the guy got through the weather was like last week, about 100 degrees, and that was the end of him. And when he came back in, he said, "You are never going to see me again," and I never did. So it has its effectiveness. Yes,
Yeah.
it does. A lot of times it's difficult to coordinate the whole thing, but probation usually has to do that anyway.
What about there's a fairly recent, I don't know if it's reached the level of a controversy yet, but court reporters versus the electronic media. I think now down in Nashua they've got several courtrooms where there's no live court reporter at all.
Those that are using the monitoring system, electronic monitoring system, seem to like it. I used it once and I frankly didn't care for it. I prefer a stenographer. I think it's more orderly for me when I want to dictate something in chambers, or I'm going from place to place. We're not talking about equipment, we're not talking about failure of equipment, we're talking about a trained stenographer who can stop a witness and say, "I'm sorry, how do you spell Valavaswego?" or whatever the word is. I think that's important. There's some danger of these being sent out of state and someone trying to spell Winnipesaukee, you know, after listening to it. I don't know. I haven't used it enough to. I'm just saying, personally, I have a stenographer wherever I go, and I prefer him. And I think what you're going to find ultimately, perhaps, is mixed as you have now. Mm-hmm. But I don't think that they're going to be letting the stenographers go and yield to electronic monitoring system. Down the road, we may have something even more sophisticated in the videos of the whole trial. That probably will be what'll come.
Have you noticed much of a change in the 10 years you've been on the court in terms of the capabilities of the stenographers and in terms of their equipment?
Well, they've gone into computers. Oh, sure. I mean, they can rap out transcripts in no time flat, the ones that have them. Most of them have them. Oh yes, it's much better, much, and I don't believe they had them. They were just starting about 10 years ago, or at least I think Bob Perry was one of the first ones up in Carroll County.
To get a computer.
Right.
Yep. Speaking of Carroll County, I wanted to ask you about the building up there. I know that's been something, it's an old building, and it's been something that you've paid a lot of attention to in the last few years.
Well, when I first went up here in 1985 or 86, within that time, the building was it was built in 1916, and it was not in good condition at all. It's a beautiful, beautiful courthouse. The original one burned in 1915 or 16, either on that location or next door. I believe we purchased the building from the county in 1987 or 88, somewhere in there, for $1.
Mm-hmm.
And at that time, there were some rumblings that they may put the ball to it, and I just couldn't see doing that and build a new building. First of all, I thought it was unrealistic, where we had other courthouses that needed to be replaced.
Needed it sooner.
And needed a newer courthouse, like Rockingham County, for instance, than Carroll. So I talked to Chief Justice Dunphy about it, so then he sort of placed me in charge of doing the renovation as best I could. And that's what I've been doing since 1988 and early 89, trying to get some money from anywhere where I can get it. And we have, it is vastly improved and completely, the courtroom has been completely renovated. New carpets, all the furniture has been stripped and redone with polyurethane or whatever. I'm still trying to get a courtroom downstairs. I seem to get to right to the door and it gets slammed in my face, but I'm still optimistic about it. But it needs a second courtroom for a master and for a second judge on occasion. But they painted the outside, and there's the new parking lot extending. So there's a lot of that's been done with very little money. We just don't get any money. And then there are other priorities that should take precedence over Carroll County. So it's understandable. Disappointing, but understandable.
Okay. Can you tell me something about the court clerks and how their role dovetails with that of the judges?
I think the clerk is probably the most important person in the whole courthouse. A good clerk is a must for a judge. I think the better the clerk, the better the judge, because certainly you can help the judge procedurally and watch out that the judge doesn't make obvious errors. I know myself, I'm in Belknap County most of the time, and Dana Zucker is clerk and an excellent clerk. And how many times when I'm doing something, not a lot, but enough, he'll say, Judge, what the hell are you doing? And I'll say, well, obviously I'm doing something wrong. He'd say, yeah, you are. I like that. I like that. I like law clerks to tell me, what are you doing? You're doing something wrong. Because, and most of the time I was. And some of the times that he doesn't catch me, I end up getting reversed. So I think they're very, very important. To me they are, anyway, as a judge. I rely on them heavily for a lot of reasons. Do
you find that the court clerks and the law clerks do tend to ask questions about what you're doing, or are people more inclined to say, yes, judge, no, judge?
If they work for me, I don't want them to do that. I think you'll remember that. I want you to tell me when you think I'm wrong. I may not agree with you. And I remember one time that I violently and vehemently disagreed with a law clerk. She disagreed with me over in Cheshire County. And I said, I know what you're telling me, I know what the law is, but do it anyway. And she finally talked me out of it. And I went to the Supreme Court, and I got reversed. I was right the first time.
Oh, no.
So,
a law clerk's worst nightmare.
No, well, she was a wonderful law clerk.
What about the lawyers? You've seen an awful lot of lawyers come and go in the 14 years with the district court and 10 years with the superior court. What kinds of things stand out in your mind or are impressive to you and make you say, hey, that one's pretty good?
Well, I think the first thing a lawyer's got to do is be prepared. And I don't care how smart they are. If they're not prepared, they're not going to win. Or they're not going to present their case properly. So that's the first ingredient of being a good lawyer. Mm-hmm. Most lawyers have the knowledge, or they wouldn't have got out of law school and get past the bar. But many of them are not prepared or don't know how to prepare. They're not organized. You've got to organize your work, organize your witnesses, prepare your findings and rulings of law, and do it in an orderly fashion. Present the story to the jury or to the judge. Unfold it as though you were doing a narration of a script for television. That's the story you want to tell. And that's, if you get that to the jury or the judge, you get a better chance, because now he knows exactly what you're talking about. Don't do things unnecessarily. Don't antagonize. Don't ever get mad or show that. You can go out and pound your fist against the wall, but don't do it in the courtroom. I think those are the things that basically makes a good lawyer. And usually the hard-working lawyer is, and the one that prepares the best is the best. And you don't have to be a genius. You know, at one time they said, when I was in law school, they said, those that get A's become professors. Those that get B's become judges. And those that get C's become the good lawyers who make all the money. And I did have a B average.
I was going to ask.
Strangely enough.
Well, that leads to the next question. What about the judges? And you spent quite a bit of time on the Judicial Conduct Committee.
I spent 7 years on the Judicial Conduct Committee.
What makes a good judge, and what makes a bad judge, and one who might be likely to end up in front of that committee?
Temperament. Plain and simple. Most of the cases you get is somebody that blowing their stack or saying, you know, chewing somebody out. Most of the cases that go there are not even, shouldn't be there in the first place. They're unfounded because they have to do with a decision that a judge makes. Now, that's not judicial misconduct. He may be right, he may be wrong, but there's appellate courts to take care of that. I think those are the majority ones that we had when I was on there. We did have some where, I know on a couple of occasions, I had to go and talk to district court judges whom I knew that we handled it that way. Say, look, this is what you did. It doesn't rise to a violation of the code in the strict sense where we should publicly censure you, but this is your warning. And that was the end of it. So those are the type of, but usually it had to do with the judge's temperament, how we handle things, delays in deciding cases. I mean, those are violations. And I believe I don't recall how many we censured, really maybe only one or two, and not very many, really, where we. But I think that with a judge, I think his first thing is to have common sense, good judgment, but temperament, I think, is the most important thing. What is knowledge of the law, fundamental fairness? I mean, those are just some of the ingredients that make up a good judge. And I can remember writing something back for the bench book for the district courts. I called it Tips for Judges, and I'll just recite a couple of them, a few of them, but and we have that in our Superior Court bench book. As a matter of fact, I gave it to the Judicial College when I was out there in 1984. Be firm, fair, polite. Maintain a balanced sense of humor. Don't be so stuffy that people are afraid of you. A good sense of humor at the right time, the right place is good. Sometimes it probably isn't. Decide without delay. The public expects it, and they should get it. Give people an opportunity to talk, to speak. What is it they want to say? Don't gag them. Don't try to stop them from saying what they want to say. You don't let them ramble on forever, but within reason. Be patient, and dignified. And here's something that came from some great philosopher: to hear courteously, to answer wisely, to consider soberly, and decide impartially. Socrates. So that's how far back that goes about judges. So.
Now, there's one on that list that I particularly liked that says to remember that you are appointed and not anointed.
That's the last thing I said. Right.
Did you ever get a sense that there were many judges around who were anointed?
Oh, I think over the past 35 years, I'm sure I run into a few that have. Maybe more than a few.
Now, you'll be retiring next year,
Yes.
and you'll be 65. You could stay on till you're 70. Why not?
Burnout. 25 years as a trial judge is a lot of years. I think, if I had gone to an appellate court, it might be different, a different type thing. There's a lot of pressure day in, day out, and every day somebody else's problems are coming. And we can't sit down and do all the research and then write an opinion. I'm not saying any more about that. I mean, that would be a little bit different where you could have a more relaxed atmosphere, but we're in and out of the courtroom all the time with our juries, domestic cases, injunctions, constantly all day. I mean, the docket is loaded. After a while, you just say to yourself, do I have to do this? And my answer is no, I don't. So I'm not going to.
What are you likely to do in retirement?
Well, the first thing I thought of was nothing, because I haven't done nothing since I was 13. But I don't believe I'm made up that way. I'll either teach or something of that nature. I'll do something. Or maybe even do ADR work, or I don't know. I'll do something. I think the first month or two that I'm off, I'm just going to do what I say is nothing.
And this is my last question. What is it that you're going to miss about this career you've had, if anything?
Oh, there's a lot I'll miss. I certainly miss people. I love people. I love to be around people. I love to converse. I love to tell and hear nice jokes. And I think that everyday hubbub can be exciting sometimes, and you have to pit that against what I just said a few moments ago. But I intend to still preside until I'm 70. The good Lord willing, it keeps me that long. To visit the courts, and even just do what Judge Cardis does every day, goes over to Cheshire County and just goes in and talks to people and has fun. I think I'll miss being a judge, I know that. I missed practicing law. I did when I became a judge, and I think I'll miss this too. But to say anything more specific than that, I don't think I can.
Fair enough. Is there anything else you'd like to add?
No.
About anything?
No, I can't think of anything.
Okay, well, thank you very much.
You're very welcome, and thank you, Debbie.